Thank you, Mr President. I'd like to thank honourable members for their contribution to the debate. The Honourable Damien Tudor-Hope, the Honourable Tanya Mihalik, the Honourable Robert Borzak, the Honourable Amanda Conn, the Honourable Anthony D. Adam, the Honourable Susan Carter, the Honourable Jeremy Buckingham, the Honourable John Ruddick, the Honourable Steve Lawrence, the Honourable Kate Fairman, the Honourable Abigail Boyd and the Honourable Sue Higginson. I wish to address some of the matters that have been raised in the debate. The first subject matter title being potential undue restriction of freedom of speech. It has been suggested that the bill may inappropriately restrict freedom of speech. Freedom of speech and expression are very important principles, but it is appropriate that they have some limits when these freedoms compete with other important principles that our society seeks to uphold, such as the freedom to live without fear or abuse, hostility or hatred. At the state and federal level, there are already a range of established limitations on freedom of speech, such as through secrecy and national security laws and defamation laws. These restrictions are consistent with our common law tradition and with international human rights protections. The prohibition in the bill does not make offensive or distasteful speech or actions unlawful. This is the case whether the speech or action is a statement of religion or a criticism of religion. Instead, it makes it lawful to incite hatred, serious contempt, or severe ridicule against a person or group on the basis of religion. This is already a relatively high requirement, which only a limited range of public speech or actions will actually meet. In addition, the bill includes appropriate exceptions that balance the protection from religious vilification with other principles such as freedom of expression. The exceptions are consistent with those used in the existing vilification provisions in the Act. One exception is for actions done reasonably and in good faith for a range of purposes, including academic, artistic, scientific research, or religious discussion or instruction purposes, or for other purposes in the public interest. This exception is intended to prevent vilification laws from being used to stop legitimate public discussion and expression on contentious or important issues or the expression of religious views. So the government believes, Mr President, that we have got the balance right. The other area that was canvassed during the debate is the potential to use the complaints process inappropriately. It has been suggested that people will abuse the complaints process by bringing frivolous complaints of religious vilification. There are a range of existing safeguards in the Anti-Discrimination Act to protect against frivolous or unmeritorious complaints. These include standing requirements and a mechanism to allow vexatious complaints to be declined. Existing safeguards in the Act include Section 89B, which allows the President of the Anti-Discrimination Board to decline a complaint for several reasons, including if no part of the conduct complained of could amount to a contravention of the Act. Section 92 also allows the President to decline a complaint during investigation if the President considers that the complaint is frivolous, vexatious, misconceived, or lacking in substance. If the President declines a complaint during investigation, the complainant may request referral of the matter to the New South Wales Civil and Administrative Tribunal. The Tribunal's leave is required for these proceedings. Finally, Section 88 provides standing requirements for making a vilification complaint. These requirements mean that the complainant must have a claim to have the characteristic without sufficient reason to doubt that is the ground for the complaint. So there are quite rigid tests, Mr President, to make sure spurious claims are by and large eliminated. The other subject matter that was traversed in the debate is the area that concerns that religion should be protected from discrimination. I think this was the essential tenor of the One Nation submission. It has suggested that the bill is insufficient to protect people of faith because it does not add religion as a protected attribute under the Anti-Discrimination Act 1977. The Greens have suggested the bill should be rejected until the Law Reform Commission has finalised its review of the Act. To implement the government's election commitment, and I would reiterate to the House that this is another election commitment that the government is making good on forthwith, the government has tasked the Law Reform Commission, as was traversed during the debate, to review the Act as a whole, which will include the discrimination provisions. This review will consider whether religion should be included as a specific ground for discrimination. Religious vilification is something we should address now, as it is a real issue that is causing real harm. It was well ventilated during the election campaign, Mr President. It is a discrete issue that can be addressed by the straightforward amendments in the bill, which are consistent with the existing vilification provisions in the Act. The bill will remedy a gap in the existing vilification protections in the Act by explicitly extending them to religion. Religion is currently protected from vilification in an inconsistent and limited manner through the ground of racial vilification. It is appropriate to explicitly provide this protection from vilification to all religions and religious beliefs. I'll now go to some of the concerns raised by the Greens. The Greens have raised three main issues with the bill and have indicated they will move amendments in relation to these. These amendments are unnecessary. I will address the three issues in turn. First, the protected grounds issue. The Greens have suggested that the expression of the grounds for religious vilification in the bill are too broad and go beyond the concepts used in the provisions of other states and territories. The bill has been drafted to ensure the prohibition on religious vilification clearly extends to vilification on the basis of religious belief, affiliation and activity. Consultation was undertaken on the bill with a range of stakeholders. Faith organisations in particular were supportive of clearly separating the grounds of religious belief, affiliation and activity. The grounds protected also include not having a religious belief or affiliation or not engaging in religious activity. This expression of the grounds for religious vilification is generally consistent with the provisions in other jurisdictions. Each jurisdiction has broadly similar formulations of the protected ground. Victoria, Tasmania and the ACT all prohibit vilification on the basis of religious belief and activity. The ACT and Tasmania also prohibit vilification on the basis of religious affiliation. Queensland's provisions do not define the term religion for the purposes of religious vilification. Queensland includes a concept of religious belief and religious activity for the purpose of its discrimination provisions. The grounds for vilification set out in the bill are consistent with those in other jurisdictions that maintain religious vilification provisions. The other area that was raised by the Greens is the limiting of protection to lawful religious activity. The Greens have suggested that the protections in the bill should only apply to lawful religious activity. This change is unnecessary. I'm advised that the common law concept of religion already incorporates an element of lawfulness. Because of this, I'm advised that it is likely that unlawful religious beliefs or activities would not fall within the scope of the protection from vilification created by the bill. In addition, the ACT and Tasmania do not confine their religious vilification protections to lawful beliefs or activities. The member for Newtown has raised concern that a person reproached or asked to move on from a safe access zone outside a reproductive health clinic would be able to make a complaint of religious vilification under the bill. Reproaching or asking a person to stop protesting in a safe access zone would not amount to religious vilification. This is because it requires that the conduct incite hatred, serious contempt or severe ridicule. In addition, the bill includes exceptions consistent with those in the Act's existing vilification provisions that balance the protection with actions done in the public interest. Actions done reasonably and in good faith in the public interest, including public discussion and debate, are not made unlawful by the amendments. The last category I will traverse in respect of the Greens' concerns is confining application to natural persons. And this wasn't just a Greens concern, I think it was raised by other members as well, who suggested that the bill should explicitly confine the scope of the protections against vilification to natural persons. The bill is intended to apply to the vilification of individuals or groups of persons rather than to organisations, consistently with the existing vilification provisions. Amendments to address this issue are not necessary or appropriate for three reasons. One, confining the protections would be inconsistent with the existing vilification provisions in the Act, which all are expressed to apply to a person or group of persons. Two, I'm advised that a corporation or other organisation is not likely to be able to bring a religious vilification complaint in its own right due to a lack of standing. Section 88 of the Act provides that a vilification complaint cannot be made unless each person on whose behalf the complaint is made either has the characteristic that was the ground for the conduct that constitutes the alleged contravention, or claims to have that characteristic without sufficient reason to doubt the claim. So the idea that a corporation could bring an action is not valid. Previous tribunal decisions have found that the standing requirements could not be construed as applicable to anyone other than a natural person. In relation to the expression of religious beliefs and their protection, the Victorian Court of Appeal has found that a corporation cannot have a conscious state of mind amounting to a religious belief in the case of Christian Youth Camps Limited versus Cobor Community Health Services Limited. Number three, the Act already allows a vilification complaint under any of the grounds to be made by a representative body on behalf of named individuals, and this would also apply to a religious vilification complaint under the bill. Mr. President, to conclude, the Anti-Discrimination Amendment Religious Vilification Bill 2023 will amend the Anti-Discrimination Act 1977 to make it unlawful to vilify a person or group of persons on the grounds of religious belief or affiliation or religious activity. It implements the government's election commitment to make religious vilification unlawful and introduces a prohibition aligned with the existing civil vilification provisions in the Anti-Discrimination Act. Mr. President, this delivers on the Labor government's election commitment to address this issue, which, as I said in the reply, was a key election promise. We believe it strikes the correct balance between freedom of speech and the proper right of religious groups to practice their religion without being belittled or vilified. I thank the government for their support, and I thank members for their contribution. The opposition, sorry.
Thanks.